On the 30th of May 1966, a father and his son, while fishing on the Westfield River's bank in West Springfield, spotted something bigger than a typical fish drifting just below the water's surface. Out of curiosity, they made an attempt to cast their fishing net just to be certain that it wasn't a fish. To their horror, a dead body emerged. That body was of 10-year-old Lou Zukowski, who had been missing for several days. The fishermen notified the police right away, and they hurried to the location of the incident to conduct an inquiry. Around that time, Mildred and Stanley Zukowski had reported their daughter missing to the Chicopee Police Department. They were then instructed by the police to come and verify whether the body they had found belonged to their daughter. Having to bury their own child is a parent's greatest nightmare. Mildred and Stanley hoped Betty Lou would not be the one discovered deceased in the river and prayed for her well-being. Sadly, luck didn't appear to be on their side, as upon arriving at the scene of the crime, they found out that the deceased was, in fact, Betty Lou Zukowski, their daughter. About 57 years ago, on Thursday, May 26, 1966, at around 6 p.m., 10-year-old Betty Lou Zukowski, a Catholic schoolgirl, left her family's home at 293 Front Street in Chicopee, Massachusetts, after receiving a call from someone she claimed to be a girlfriend. She had supposedly planned to catch up and grab a scoop of ice cream with this girlfriend. Her parents allowed her to go since they were used to their daughter frequently going out. Little did they know, that will be the last time they would be seeing their daughter alive. Betty Lou Zukowski got ready to go. She was wearing a green shirt with checks with blue pants under, a jacket and white sneakers. She also brought a $2 bill with her. Around 11:15 p.m. that evening, Betty Lou's parents, Stanley and Mildred Zukowski, contacted the Chicopee Police Department and reported their daughter missing after she hadn't returned home. They instructed the police, for reasons unknown, not to report her publicly missing for several hours. As per some sources, they were probably accustomed to her being away from home for such a period of time. In an effort to locate her, the Chicopee Police Department did, however, promptly issue an all-states alarm. It was eventually revealed that Betty Lou's girlfriend was not actual. The search for her went on for 3 days, but yielded no findings. Unfortunately, however, Betty Lou's wounded and covered in mud body was discovered off the coast of West Springfield on May 30, 1966, by 2 men fishing in the Westfield River. This was 4 days later. Her cause of death was confirmed as severe blunt force trauma to the head, evident from skull fractures and fatal drowning, based on the autopsy report. Betty Lou hadn't been subjected to any sexual assault and was still alive when she went into the Westfield River. She was battered, according to the authorities, within 15 minutes of her drowning. Following the discovery of Betty Lou's body, the West Springfield Police Department and the Chicopee Police Department collaborated on a combined homicide investigation. At first, the entire detective bureau of each of these police departments was tasked with the case. There was also assistance from the Massachusetts State Police and the Hampton County District Attorney's Office. An in-depth search was conducted along the shore, looking for any evidence where Betty Lou's remains were discovered. Divers also combed the river for any useful clue that might identify the offender. Nothing. Even the murder weapon was nowhere to be found. After that, the detective spoke with Betty Lou's family members, acquaintances, and classmates to find out who she might have met up with around the time of her abduction and subsequent slaying. Her pals from Chicopee had informed the authorities that she liked visiting the caves carved out along the Chicopee River's bank behind the Chicopee Electric Light Company. However, despite searching all the locations she would normally go to, the police were unable to find any lead that could help them catch her assailant. Betty Lou was described as a loose girl, according to law enforcement and media accounts at the time of her passing. She was described as sharp, welcoming, humorous, adventurous, vibrant, and rebellious by her friends. They said that at the age of 10 she had colored her dark brown hair blonde. She usually wore cross-shaped earrings, had her ears pierced, and applied cosmetics. Her close acquaintances claimed that she was occasionally sighted hanging out with teenage lads, mostly in their vehicles. Some suggested that, at 10 years old, Betty Lou was undoubtedly eager to grow up, and that because of her free spirit, she may have trusted someone older who later took advantage of her and then killed her. Investigators were informed by a friend of Betty Lou that she once claimed to be seeing a boy by the name of Ralph. She described Ralph as a white boy, maybe 17 or 18 years old, with black hair, brown eyes, fair complexion, and used to wear black-framed glasses in the year 1966. His estimated height was 5 feet 5 inches, and his weight ranged between 125 to 135 pounds. He either drove a dark green Chevrolet sedan or a Chevrolet with a white or light blue top and dark blue bottom. Nevertheless, the police soon discovered that there was no such person named Ralph. Either Betty Lou had lied about Ralph's actual name, or Ralph had misled Betty Lou about his name. Authorities suspected that Betty Lou knew the person who murdered her, else she wouldn't have left her home after getting the phone call on Thursday evening. Investigators suggested that she met up with that person, hoped into their car, and ended up in West Springfield. Still, there weren't any noteworthy leads throughout the days that followed the discovery of her remains. On June 2, 1966, Betty Lou Zukowski was laid to rest on her 11th birthday. Her funeral took place at Holy Name Church in Chicopee and was held with high mass honors. Pallbearers included a number of students from the Valentine School in Chicopee, where she attended 5th grade. All of her classmates and her teacher were present for her funeral. Deeply loved and full of spirit was Betty Lou. A week following the discovery of Betty Lou's body, detectives created a sketch of the suspect based on the accounts of 2 witnesses. Among those witnesses included the last person to have seen Betty Lou alive, few hours prior to her killing on May 26, 1966. This sketch, though, was consistent with Ralph's description. When the sketch was eventually made public, it received a lot of coverage in the local newspapers of the time. It provided the detectives with various leads, but none of them helped them identify the perpetrator. After all leads were exhausted, the case was put on hold for years. However, Betty Lou's murder case was revived in 2019, following the establishment of the Unresolved Cases Unit of the Hampton District Attorney's Office. Subsequently, authorities learned that in November 1997, a man named Donald Mars was deemed as a person of interest when West Springfield Police Department investigators obtained information connecting him to Betty Lou's slaying from a number of sources. But since there wasn't enough proof to link him to the crime, he was never taken into custody. 25 years later, in 2022, Betty Lou's case gained significant attention, and Donald Mars was accused with first-degree homicide on Tuesday, November 1, 2022, in connection with Betty Lou Zukowski's killing. An arrest warrant was issued for him. The 2nd of November 2022 saw the apprehension of Donald Mars. Although the evidence connecting him to the murder has not yet been made public, Hampton District Attorney Anthony Gallooni confirmed during the news conference that crucial statements had been made, which contributed to Donald Mars's arrest. It's either that someone saw something and confessed, or Donald Mars most likely implicated himself during the questioning. Donald Mars was born into an influential family in Chicopee. Roger Mars, his father, had a total of 5 sons and owned Mars Heating and Service. Apparently, 2 of Roger Mars's boys served in the military, while he himself served in Korea. Given that Donald Mars was residing in a Bedford Veterans Administration facility at the time of his apprehension, it is likely that he was one of those sons serving in the military. Donald Mars seems to have committed a number of offenses throughout his life. Donald Mars was found guilty in 1995 of 2 charges of forceful assault of a child and 3 charges of indecent assault and battery on a child below the age of 14, as per the State Sex Offender Registry Board. He is designated as a Class 3 sex offender, which means that he is deemed highly probable to commit further offenses. Following his conviction in May 1995, he was sentenced to 2.5 years in prison. He was released in June 1997 and placed on probation. He breached the terms of probation and received an additional 5 to 7 year sentence at Cedar Junction. Following his sentencing, Donald Mars was deemed as sexually dangerous and placed under civilian custody at the Massachusetts Treatment Center in Bridgewater from 1994 to 2015. Eventually, he was placed in a Bedford, Massachusetts Veterans Administration facility, a hospital where he was residing prior to his detention. At the time of Betty Lou's demise, Donald was 17 years old, and the sketch of Donald Mars created from Betty Lou's friend's description of Ralph resembles his high school yearbook photograph. Furthermore, Donald Mars had some familiarity with the location where Betty Lou's body was discovered at the time of the murder. His grandparents lived at 102 Woodmont Street in West Springfield, and according to a newspaper archive, his family would often go there. On Christmas, Thanksgiving, and other occasions, they would visit the place. This address is 4 minutes' drive from the crime site at the end of Dewey Street. Donald Mars, presently 73 years old, was brought up to a Hampton Superior Court, imposing him with count for murder in first degree in connection with the Betty Lou's murder. When asked to make a plea in a hearing held via Zoom meeting, Donald Mars pled not guilty, looking like he was about to break down. After his criminal past was revealed, he was urged to be detained without being able to post bail. This did not sit well with Donald Mars, who seemed resentful. The preliminary hearing for this case was postponed to May 1, 2023. Sadly, Betty Lou's parents passed away in the 1980s. It was reported that Mildred Zukowski, who passed away at the age of 61, fell off from the window of her room. According to some sources, she took her own life because she was apparently unable to cope with the loss of her only child, Betty Lou Zukowski. A year after, Stanley Zukowski had passed away at the age of 64 from an unspecified cause. The Zukowski family has no known siblings that are currently alive. Now that Donald Mars has been apprehended, Hampton District Attorney Anthony Gallooni has this to say. Unfortunately, Betty Lou's parents have passed away and will never get an answer from Donald Mars regarding what we believe he did to their daughter. My office, on the other hand, has been in contact with Betty Lou's extended family members, one of whom, in fact, was a pallbearer at her funeral in 1966. While this investigation undoubtedly will not bring Betty Lou back to her family or grant her the opportunity to grow into a healthy adult that she and every child deserves, it is for them and for Betty Lou that we embark on this journey of seeking justice. Numerous unsolved cold cases have been lingering for a very long time without the culprits being brought to justice. However, there is now a ray of hope for the families of murder victims, as most of these cases are now actually being solved, providing their loved ones with closure and allowing them to finally rest in peace. We hope that anybody who had committed murder or any such heinous crime would be caught before they could even get a chance to go 6 feet under the ground. On February 2, 1986, just before 10 p.m., a tragedy which stirred the entire nation of Australia took place. Anita Cobby, a 26-year-old registered nurse, had gone out to supper with friends following her shift at the Sydney Hospital on Macquarie Street, which is close to the State Parliament House within the city. She took the 9:12 p.m. train to Blacktown in outer western Sydney, where she was staying with her parents after she recently had a divorce. Just before 10, she arrived at Blacktown Station and went in search of a phone so she could reach out to her father. Cobby would typically call her father, Gary Lynch, to arrange for her to be picked up, since this was before cell phones and the station's public phone had been vandalized. Cobby made the decision to walk home. Just as she did so, a Holden Kingswood slowed and stopped next to her. She screamed as 2 of the 5 male passengers leaped out and grabbed her, forcing her inside the car. After that, Cobby was tormented, assaulted, beaten, and had her throat slit. The wound was so deep that it nearly severed her head. It took 2 days for her bloodied nude body to be found after it was abandoned in an isolated cow paddock in Prospect, not far from Blacktown. Following the discovery of Cobby's body, the government of New South Wales announced a $50,000 reward for information that would lead to an arrest. As her colleagues conducted passenger interviews, A police officer posing as Cobby rode the 9:12 p.m. train to Blacktown in an attempt to trigger recollections. Cobby's murder made headlines, and the graphic details of the crimes and the horrible tragedy emerged one after the other. The neighborhood and the entirety of Australia were, without exception, infuriated. Even the investigating police, including Detective Sergeant Ian Kennedy, one of the best detectives in his days, were profoundly impacted. It took police just under 3 weeks to identify, apprehend, and charge 5 men in connection with the murder. They were 19-year-olds John Travers and Michael Murdoch, and the Murphy brothers, Michael, age 33, Gary, age 28, and Leslie, age 22. The community detested and despised all 5 of them. Each of them had a less-than-average IQ and came from impoverished homes. They were small-time offenders who had been charged with a big one. The neighborhood's tone following Cobby's suspected killer's arrest exuded a brooding malevolence, fitting the horrific nature of the act. When the 5 accused appeared in court for the first time at the Little Westmead Coroner's Court, it became evident. Nestled within the expansive grounds of Westmead Hospital Complex, Westmead Coroner's Court was a brand-new structure when it opened in 1984. In case of trouble, there were plenty of uniformed police officers about. A dummy hung menacingly from a noose fastened to a tree branch. A sizable group of people had assembled. Many of them were wearing Cobby uniforms and holding signs advocating for the reinstatement of the death sentence. Derek Hand, the municipal coroner, served as the magistrate. After a brief round of formalities, the Hand quickly scheduled the committal proceedings for the safer confines of the coroner's court on Parramatta Road at Glebe. The crowd erupted ahead as the prison van left the Westmead Hospital. They booed, taunted, and pounded on the exterior of the van. The unrepresented defendant standing trial was greatly disadvantaged before the public solicitor and legal support. In any criminal trial, the role of defense counsel for the accused can be contentious, especially in cases involving serious crimes. Defense counsel has an obligation to vigorously and morally appropriately represent their client. There is a widespread misperception that a legitimate defense counsel needs to accept the client's innocence. That is not at all the case. A fair trial requires a capable and determined defense. It makes no difference what the counsel personally believes. It is the responsibility of the attorney to present their client's cases persuasively rather than to voice their own. The general public often overlooks this. The cab rank rule is nothing more than a restatement of the legal norm that barristers do not pick their clients. If it were the other way around, resented causes and those who were accused of them would be restricted from professional voices. For barristers, fearless independence is crucial, particularly in cases where a public defender, who occupies that independent statutory office with all of its rights and obligations, was engaged. The Crown, in its pursuit of the 5 men's convictions, adopted the legal doctrine of common purpose. The judges used the example of 2 bank robbers to explain a common purpose. With a fake pistol in hand, one of them enters the bank and demands cash from the teller, while the other drives the getaway car. The teller resists and is subsequently shot. As it turns out, the pistol was not a replica. Despite the fact that the driver has never got out of the car, both men are charged with murder. Then ensued contentious inquiries of fact and legislation. Was it agreed upon, first of all, to utilize a replica rather than an actual pistol? Determining the driver's degree of criminal liability may depend heavily on the response. On top of that, was the driver familiar enough with his partner to anticipate that he would bring and use a real pistol? Put another way, even if you have never seen the victim, let alone desired their death, you may still be guilty of murder. In the Anita Cobby case, the argument put forward by each defendant was that Travers was the only one with the knife. Cobby was stabbed by Travers alone, and only he was responsible for her demise. Whatever each of them had done that evening was irrelevant to the Crown case. Since everyone knew what Travers was going to do, they were all equally guilty of her death and murder. As a result, everyone was equally guilty. This was true for the Crown both legally and persuasively, in terms of reality and common sense. Still, there were doubts about the degree of personal involvement each of the accused had. In that regard, their signed confessions were the Crown's trump cards. The defense argued that coercion and unlawful methods were used to acquire the confessions. In order to make the case for the client, those accusations had to be presented. The authorities refused all of them. Accepting the Crown case was even one of the lines of defense that arose. In terms of legal accountability, manslaughter was the worst offense that could be traced back to Murdoch, along with the murder fees for the death. Even though the line of argument lacked intellectual integrity, it still needed to be persuasively presented to the jury. Was Travers alone responsible for the murder? And the remaining four, one or more of them, only guilty of manslaughter? The trial started on March 16, 1987, at Darlinghurst's historic No. 5 Court, the Central Criminal Court. The bar table filled with 5, certain times 6, robed barristers and their instructing solicitors for what the press dubbed the trial of the century. The day the trial started, there was an absence of the typically serious atmosphere at Darlinghurst. Numerous prospective jurors gathered in front of the pillars made of sandstone, extending onto the lawns that faced Oxford Street and Taylor Square. There appeared to be radio network reporters and television crews everywhere. On the left side of the judges, facing the jury, were the press's customary reserved prime seats. The topic of whether the public prefers symbolic or actual representation of serious offenders was addressed by this trial. Our noble, albeit not flawless system, does not declare an accused person guilty until it has completed its entire course. The stunning injustices that have marred our past serve as a reminder of the ongoing risks associated with human fallibility. With very few exceptions, all judicial proceedings are publicly accessible and, perhaps more crucially, come under close media observation. This serves as a significant protection. For this trial, it was most definitely present. Counsel has a minimum of 2 choices in scenarios like this when there is legitimate community ire. To make it seem as though the procedures for a fair trial were followed, all that needs to be done is go through the motions. Alternatively, the counsel takes the appropriate action in each case, that is, to provide a client, who wouldn't know what it entails, your best professional effort. Alan Saunders, QC, stood up to his reputation when he presented the jury with the Crown evidence, going into extensive detail about the callousness Anita Cobby endured. Cobby was subjected to prolonged depravity, which he characterized as brutal, unbridled lust, culminating in one of the most savage, brutal murders the state has ever known. No wonder why the media dubbed it the century's trial. The first witness, Cobby Lynch's father, Gary Lynch, established an atmosphere of unfathomable sorrow. He was a robust and respectable man. He provided a brief formal identification of his late daughter. The stillness in the courtroom was deafening as he did so. After that, he accompanied his spouse to the rear of the court, where they stayed throughout the trial. Every day, Gary and Grace Lynch were present at the trial. They exuded a great deal of dignity. Police concerns led to strict security measures, including searches of attorneys and galleries following each adjournment. Cobby's parents frequently had to wait in line with the attorneys for their daughter's murderer during this process. They never once showed anything but class, decency, and convention, which kept them from expressing themselves in any adverse manner. Since Cobby's torture lacked eyewitnesses, the individual confessions served as the main source of evidence. It is important to note that one person's confession could not be used against another in court. This indicates that while the confession can be used to establish the writer's guilt, it cannot establish the guilt of any of the other accused parties it mentions. Given that the confessor might wish to place the blame on the co-accused, this is a reasonable and safe approach to view confession. To decide whether or not each accused person is guilty, the evidence should be reviewed by a jury. The only exception to this rule is if a co-defendant concurs with another's confession in order to persuade them to implicate themselves, even slightly. Although not illegal, the tactic is not encouraged. A little but crucial criterion is to accept the confessor's account solely against the person who made it. The primary advantage for the Crown was that each accused person's own statements to the jury served as evidence, saving them from having to depend solely on circumstantial evidence. Sadly, there was no disputing the unfortunate fact that Anita Cobby had been murdered from the very beginning. First and foremost, the trial concerned the involvement of all or any of the accused. Second, the extent of involvement in the event that the matter was resolved negatively. And third, after determining the extent of legal liability, the question of whether the specific accused was guilty of murder or manslaughter. Part of Michael Murphy's case, as well as his two brothers and Michael Murdoch's, was that Travers inflicted the fatal stab wounds on Cobby with a knife and was acting on his own behalf. To this, Travers had entered a guilty plea. Regarding the murder charge, there wasn't really any concrete proof to back up a conviction of the others for murder on the grounds that they helped or urged Travers to kill himself. Michael Murphy allegedly said, "I didn't want her killed," to the police. "Travers is a lunatic. It's his fault. I told him not to kill her." Legally speaking, the defendant argued that they had neither willfully helped Travers perpetrate the murder nor been a party to a coordinated effort to commit the murder. Technical juridical jargon was not what that was. It was essential. Although they denied it, it must be acknowledged that in the Crown case, there was evidence that they were legally accountable for the murder and other serious crimes as co-offenders, either as principals or as accomplices. Throughout the trial, the defense aimed to highlight the favorable aspects of the case rather than addressing or highlighting any biased evidence. However, the stark reality of the situation was that there weren't a lot of favorable elements. The defense of Michael Murphy was a nightmare for the law. He was innocent of all crimes according to the instructions he gave. As per legal provisions, witnessing a crime being committed does not constitute a crime. Yet to suggest that John Travers, who entered a guilty plea, murdered the person voluntarily is what co-accused him of. The police photos of the site and the post-mortem details were even more disturbing than the transcript of the accused's testimony. Once again, what was the client's defense? "I wasn't there, and if I was, it was for sex and not for murder." Just putting those awful alternatives out there highlights the tremendous challenge that the defense had. This unanswerable dilemma always loomed large, given that the Travers argument is based on a lunatic's defense. Why then ever spend time with him? The jury spent the entire day in closed session at an undisclosed location. They were evidently diligent, and they frequently turned to Justice Maxwell for assistance. All correspondence was appropriate and conducted in an open setting with the accused present. It was now the morning of the sentence. There was a little wait at 10 a.m., since Anita Cobby's parents weren't in court. There was nothing left but the ceremonial rite of judgment when they arrived. All in the court believed they already knew the outcome. Life sentence. Nevertheless, there still was the possibility that release one day would not be omitted. The judge came in and took a seat. Then, the 5 defendants were hauled up into the dock together for the first time since the first day of the trial. There were police everywhere you looked. The courtroom had an atmosphere of unheard of anxiety at one point. The emotions were so intense that even the skilled, composed, and well-respected Judge Maxwell shed a few tears. The press captured him pausing, with tears in his eyes, and taking a sip of water before continuing. The defense counsel had never seen a judge so distressed as they had faced an impossible challenge in trying to persuade the jury to grant them a calm, detached hearing. The solemnity of the Central Criminal Court was replaced by raucous scenes as uniformed sheriffs haplessly attempted to re-establish order after Maxwell formally handed down the penalties, which included life in prison. The court had briefly fallen into an unpleasant commotion. Furthermore, Maxwell listed and sentenced each of the 5 with the following offenses: abduction, 16 years. Theft, 17 years. Robbery with trauma, 17 years. Intentional bodily harm, 12 years. And theft of a motor vehicle, 5 years. To put it plainly, the lengthy simultaneous prison terms imposed were purely academic gestures. Maxwell stated in the closing, "The circumstances of these prisoners and the circumstances of the murder of Anita Cobby prompt me to recommend that the official files of each prisoner should be clearly marked, never to be released." If you find this video compelling, show your support by giving it a thumbs up, subscribing to our channel, and ringing that notification bell. By doing so, you'll stay updated about the latest investigations and mysteries. Your support means the world to us as we continue to pursue the truth in the world of unsolved cases.